A very, very good evening to all of you, friends. A very, very good evening to all of you. Wish you all a very happy new year. So, friends, today we are back with this very important session for those of you who are preparing for SLAT, NIMS, Maharashtra CET, and other law entrance examination. So, ALIT and CLAT is over. Now, there are a number of examinations that are coming, okay? And I'm sure that you guys will be preparing for these examinations also. Now, one of the most important things, one of the very important things that you must understand at this juncture is the fact that when we are done with ALIT and CLAT, the national law schools as well as along with NLU Delhi, these two exams are over. Now, there are a number of examinations, right? Now, these examinations include Symbiosis College, then you have NIMS, and then you have Maharashtra CET, which is the gateway to the very many law schools in the state of Maharashtra. So, in these sessions today, we shall be talking to you and deliberating about certain very, very important legal reasoning questions which has a high probability for each and every one of you watching to come in this examination. तो क्योंकि अभी एलेट और क्लैट खत्म हो गया, अभी आपके पास महाराष्ट्र सीईटी, निम्स और सिम्बायोसिस लॉ एडमिशन टेस्ट बाकी है, इसके वजह से हम लोग ये सेशन लेके आए हैं. ओके, so guys, let's get started. Okay, now what are the agenda for today's session? There will be 3 passage based questions, a number of questions. There will be total 17 questions that we shall be discussing in the course of this session. Okay, now passage based questions are over insofar as CLAT is concerned. So in CLAT you had passage based questions, but insofar as Symbiosis, NIMS and Maharashtra CET examination is concerned, the kind of question they ask you is little different from what is generally asked in CLAT and ALIT. Now, before we begin, BYJU'S Exam Prep brings to you CLAT 2024 scholarship test on 8th of January 2023. So register now to get 90% scholarship on the BYJU'S Exam Prep CLAT 2024 courses. Now, sit for this scholarship test, and if you get selected in this scholarship test, then you get 90% scholarship. That's a huge amount of money that you save for enrolling yourself to BYJU'S Exam Prep. So get your scholarship done on the 8th of January 2023 at 11 a.m. Register now. Now, many congratulations to Anika Sehgal, who was a part of the 1-year online classroom program. She has got an AIR rank of 18. So many congratulations to Anika Sehgal for getting such a great and fabulous score in CLAT 2023. Now, let's begin with the first question. So, चलिए बच्चों, अभी हम लोग थोड़ा क्वेश्चंस देखते हैं कि कैसे कैसे क्वेश्चंस आते हैं. नाउ महाराष्ट्र सीईटी और आपका निम्स और आपका जो सिम्बायोसिस लॉ एडमिशन टेस्ट होता है, स्लैट होता है, द काइंड ऑफ क्वेश्चंस दे गिव यू, दे आर mostly principle and fact based. So read the principle and the facts. There will be options coming in the next slide. Read it and tell me the correct answer. Okay, for the first couple of questions, let me help you in how to solve these questions. Let's read the principle. The principle says no communication made in good faith is an offense. So if a communication is made in good faith, it is not an offense because of any harm to the person to whom it is made, if it is made for the benefit of that person. So if you make a communication in good faith for the benefit of that person, and because of that communication certain harm is caused, you will not be punished under the law. Let's read the facts. Yoda was admitted to a hospital. Yondu, the doctor, diagnosed him and informed Yoda that he was suffering from stage 4 cancer and he might not survive for more than a year. Listening to this, Yoda got a heart attack and died on the spot. Yoda's family accuses Yondu for Yoda's death. Now, here is this particular situation. Here is this particular situation where a doctor informs the patient that he is suffering from a particular disease, stage 4 cancer. He might not survive for more than 1 month. Listening to this, the patient dies on the spot owing to a heart attack. What does the principle say? No communication made in good faith is an offense which is made for the benefit of that person. Let's read the questions, the options. Sorry, let us read the options. Okay, are you understanding now? Please read the options and tell me. Is the doctor liable? What does the principle say? If a person has made any communication in good faith for the benefit of that individual, now that it is the duty of the doctor to inform the patient what he is suffering from. Is it not the duty of the doctor? So will the doctor be held liable? No, he will not be held liable. So the correct answer is option B. The doctor, Yondu, will not be held liable for the death because the communication was made in good faith. It was made in good faith. Am I clear to each and every one of you? Am I clear to each and every one of you? Is that clear? Very good. Zoya Khan, Sheikh Kaif, very, very good. Very good. Is that clear? So this is how we have to solve the questions, okay? Let's move ahead. So the correct answer is option B. Yondu will not be liable for Yoda's death as the communication was made in good faith, and according to the principle, no communication made in good faith is an offense because of any harm to a person made by it for the benefit of that person. So option B is the correct answer. Okay, very good. Chalo. Moving on to question number 2. Read the principle. Communication of an offer. What is communication of an offer? That is given in the principle, and the facts deals with a particular situation. Read the situation very carefully. Treon made an offer to sell his mansion in King's Landing at a price of 5 lakh and directed Peter. So Treon makes an offer to sell his mansion in King's Landing at a price of 5 lakhs and directed Peter, his servant, to communicate that offer to Robert. So Treon is making an offer to Robert through Peter, right? So Treon is making an offer to Robert through Peter. That's it. Robert accepts the offer and the acceptance was communicated to Treon. So Robert says yes. The offer was made and Robert accepts. And he tells that offer to Peter. Acceptance was communicated to Tryon by Peter. The acceptance was communicated to Tryon by Peter. According to the terms of the contract, Tryon asked Robert to pay the sum of money, but he refused. Robert contending that the contract is not valid. Contract is not valid. Is Robert correct? Let's see. Was the acceptance complete? Yes, it was complete. Is it a valid agreement? Is it a valid contract? Yes, it is. So, as the offer was communicated to him by Peter on behalf of Tryon, and there is a valid contract as he accepted it. Very, very important. So, the correct answer is option A. The correct answer, beta, is option A. Very good. Is that clear? Every one of you? Okay. Very good. Very good. So this is how we are going to solve the questions. It is stated in the principle that the offer to be communicated to the person to whom it is interested is made. Hence, the fact that who communicated the proposal is not something to be looked into. The fact that the offer was made to Peter, the servant, did not matter as it is communicated successfully to Robert and is accepted after consultation, a valid agreement. So the correct answer over here is option A. Let's move on to the third question. When is robbery? When does robbery becomes extortion? When does robbery becomes extortion? That is the principle given, right? If you are putting another person in the fear and commits the extortion by putting that person in fear of instant death, instant hurt, instant wrongful restraint to that person. So if you are, suppose I say, now let's read the facts. I will not give you that explanation. If I give you that explanation, everything will become easy. Ross obtains property from Joe by saying, your child is in the hands of my gang and will be put to death unless you send us 10,000 rupees. Is Ross liable for robbery? Or is it extortion? Is it robbery? Is it extortion? Please tell me the correct answer. Yes, he put Joey under the impression of instant death of his child. Okay. No, this is extortion and not robbery. Okay. No, as this is theft and not robbery. Yes, as extortion always amounts to robbery. No, these are elimination of the wrong answers. This is extortion and not robbery because he did not put Joy in fear of instant death of his child. Okay, we will put an asterisk over here. Yes, he put Joy under the impression of instant death of his child. So the question was, is Ross liable for robbery? No, he is not liable for robbery. He is liable for extortion. So the best answer among these two, A and B, is B. Is B? B is the right answer. These two cannot happen. If you see this, if you read the question, what does it say? Is Ross liable for robbery? No, he is not liable for robbery. He is liable for extortion. Right? Every one of you. Is that clear? Everyone. Okay. Okay. So guys, those of you who are watching me live, I would request each and every one of you to share this session with your friends so that those of you who are preparing for Maharashtra CET, SLAT, and other law entrance examination can take benefit of it. Okay. Do share and like. Let's move on to question number 4. If you are betting on things, you cannot recover the money. That is what the law is, because it is a wagering agreement. Okay. Okay. Is the agreement between Raja and Harish valid, or is it not valid? That is a simple question that you must have to look into. Okay. The agreement between Raja and Harish, is it legal, is it illegal, or void? You have to see that. Now, the agreement between Raja and Harish is void. Okay. The agreement between Raja and Harish is absolutely void. That is the answer, because it is a wager. It is a wager. So it is void. Am I clear? So the correct answer is option C. It is a wager. This agreement between Raja and Harish is a wager. Right, everyone? Okay, before moving ahead, BYJU'S Exam Prep brings to you CLAT 2024 Comprehensive Course. Secure a seat at your dream NLU. What are we going to provide in this comprehensive course? 300 plus recorded videos, very, very important. 300 plus hours of live classes, 35 mock tests for CLAT and other law entrance examination with video solution, monthly e-magazine for current affairs, and the content is curated based on the analysis of last 5 years of CLAT question paper. So those of you who are preparing for CLAT 2024, we have this fantastic CLAT 2024 comprehensive course. Moving on to question number 5. Let's read the 2 principles. Adam and Eve make a contract grounded on the erroneous belief. So they had a false belief about a particular fact, that a particular debt is barred by the Indian law of limitation. Now decide the validity of the agreement. Now see, principle number 1, when both the parties to an agreement are under a mistake as to the matter of fact essential to the agreement is void. This is important. A contract is not voidable because it was caused by a mistake as to any law enforced in India, but a mistake as to a law not enforced in India. Hence, the same effects as a mistake of fact. Very, very important. Principle number 2. Principle number 2. Let's see the correct answer. Is the agreement void or not void? The agreement is voidable, is voidable, is void. The agreement is valid. It's not voidable as the parties were under a mistake of an Indian law. Am I clear, everyone? Is that clear? So over here, the principle number two says a contract is not voidable because it was caused by a mistake as to any law enforced in India. Principle number 2, first part makes it absolutely clear what the answer will be. Am I clear, everyone? Okay. Is that clear? So the correct answer is option B. Principle number 2. Principle number 2 is the, if you have to just read principle number 2, understand the facts and click on the right option. Okay. Question number 6. So you go to a bank, there is a person, banker, sitting over there. You say that this is my 10,000 rupees, please deposit my 10,000 rupees in this account. You fill up those forms and he goops it up. He credits that amount in his own personal account. Master is liable for the wrongful acts of the servant in the course of employment. Is the bank liable? Bank shall not be liable. They was acting outside the course of employment. Bank will be liable. It is a fraudulent act of Dave. And who is the master of Dave? Is the bank. So the bank will be held vicariously liable for the wrongful acts of its servant because it was done during the course of employment. Is that clear? Okay. The correct answer is option E. Is that clear, everyone? Moving on to question number 7. Volenti non-fit injuria. A person cannot complain against harm to which he has voluntarily consented. Precautions can be taken only against reasonably foreseeable mishaps. Aditya went to the Wankhede cricket stadium to witness a match between Mumbai Indians and Delhi Capitals. In the 18th over of the match, Aditya's favorite batsman hit a 6 and the ball hit Aditya in his head and has rendered him unconscious. Is Aditya entitled to claim damages? Now, suppose you go to watch a particular match and you know it's a cricket match. People can hit 6 and 4s, right? If they hit a 6, it is going to come into the galleries. Now, you are sitting in the gallery to watch this match. Now, you get hit by this certain 6 that comes from your favorite batsman. Now, can you claim any damages? The principle says a person cannot complain against harm to which he has voluntarily consented. The moment you buy that ticket, you consent to that injury, or else stay at home, watch it over the television. Who is stopping you? But you want to enjoy the atmosphere of the stadium. ठीक है, आपको स्टेडियम का मजा भी लेना है, तो उसके साथ तो थोड़ा तो डेंजर तो है ही. कोई छक्का तो मार ही सकता है, सिक्सर तो मार ही सकता है. Am I clear, every one of you? Is that clear? So the correct answer is Aditya is entitled to damage. Aditya is entitled to damage. Aditya is not entitled to damage. Okay, as he should have exercised caution. Aditya is not entitled to damage as he has agreed to the injury. So the correct answer is option D. See, both are no, but among C and D, D is a better answer. So your answer has to be option D. Is that clear? Everyone? The moment you purchase the ticket of the match, you arrive at the stadium to watch the match, you have consented to some of those injuries. Am I clear to everyone? Am I clear to each and everyone? Okay. Moving on to question number 8. Extraordinarily heavy rainfall, heaviest in human memory, which resulted in the overflow of water, and the lakes washed away 4 bridges belonging to Ruman. Now, is it an act of God? Now, what is an act of God? A natural activity with an unnatural force. Is rainfall a natural activity? Yes. Is it with an unnatural or an extraordinary force? Yes, it is. Right? Is that clear? Yes. Tell me, what is the correct answer? Is it an act of God? Yes, it is an act of God. It is an act of God because the event is exceptional and could not have been anticipated by Umang. So the correct answer is option C. Very easy. ठीक है बच्चों, समझ में आ रहा है क्या नहीं? Okay. Okay. ठीक है? So the correct answer is it is an act of God. Moving on to question number 9. Injuria sine damno means injury without damage. Injury means violation of legal right without damage. So violation of a legal right. There is a violation of a legal right, but there is no loss. For example, trespass. If I enter your land without your permission, there is a violation of your legal right. You can take me to the court. But what, have you suffered loss? Have you suffered any loss? The answer is no. So the correct answer is option D. Okay. Zoya Khan says, पिछले वाला क्वेश्चन का why not A? What was the question? Will Umang be entitled to take the defense of act of God? Yes. Yes. सी और डी में कंफ्यूजन हो सकता है, ए और बी में तो कैसे कंफ्यूजन हो सकता है? See, between C and D, C is a better option because it talks about event in exceptional condition. Could not have been anticipated by Umang. Did you understand, Zoya? ठीक है? Okay, is that clear? So the correct answer to this question, question number 9, is option D. Okay? Injuria sine damno. ठीक है? Let's move to question number 10. Let's move to question number 10. The government has a policy that in a woman college or in a woman college, only a woman can be the principal. A male teacher cannot be a principal. That is what is given. Okay, is that clear? And here is a man who has applied for the post of the principal. His candidature is rejected on the ground that he is a male. He challenges that rule of the government which says that in a woman college, only a woman can be a principal. Okay. Now, question number 10. Yes. Does it amount to discrimination? Now, what does the principle say? The principle over here says reasonable classification having nexus with the object sought to be achieved does not violate Article 14 or 16. If there is a reasonable nexus, so the government thinks that in a woman college, the principal of the college has to be a woman. Am I clear? In a woman college, the principal has to be a woman. Is there a direct nexus between the two? Yes. So the correct answer is the rejection does not amount to discrimination since there is a reasonable classification permissible under the Constitution. There is a reasonable classification which is permitted under the Indian Constitution. Is that clear? Please read the solution, the explanation. Is that clear? Each and every one of you. Okay. Question number 11. Read the principle, the facts, the order. In order to convert a proposal into a promise, acceptance must be absolute and unqualified. Okay. So your acceptance has to be absolute and uncodified and qualified. Ramesh listed his house to sell it. Okay. Ramesh wants to sell it house. Suresh shows interest and inquired about the asking price. Ramesh asked for 10 lakh rupees. Suresh responded that he is willing to pay 8 lakh rupees. So I say I want to sell my pen for 10 rupees. You say I am willing to buy it for 9 rupees. So you have not accepted my offer. Ramesh sold his house to Mahesh for 10 lakh rupees. Now Suresh is suing Ramesh for damages. How? There was no, you did not accept my offer. You did not accept my offer. Will Suresh get any compensation? Will Suresh get, was there a valid contract in the first place? I say 10 lakh rupees, I want to sell my house. You say no, 8 lakh rupees. There is no contract, there is no communication. Everything falls because your acceptance has to be unqualified. Someone else says, okay, I'm willing to buy it for 10 lakh rupees. I sell it to him. So the correct answer over here is option D. What is nexus? Zoya Khan, nexus means there has to be a linking. There has to be certain link. Reasonable nexus. Okay. Yeah. Okay. So guys, if you are liking this session, do press the like button because it's a very, very important session, and share this session with your friends. Suresh will not be entitled to any compensation from Ramesh as he did not accept Suresh's proposal. So option D is the correct answer. Moving on to question number 12. No person shall be prosecuted and punished for the same offense more than once by a judicial authority. Departmental proceedings are independent of trial by judicial courts or tribunal. Eric, a school teacher, was accused of sexual harassment. A case was initiated against him. The magistrate has awarded him punishment for 6 months. Meanwhile, the school management instituted an inquiry and found him guilty. They terminated him. Now, Eric challenges that termination as not valid because he has already been punished with imprisonment. So the court says, so here is a teacher who has been found guilty of having committed sexual harassment. The court sends him to jail for 6 months. There is a departmental inquiry that takes place in the school. The school authorities terminates him. He challenges, saying that double jeopardy, that no person shall be prosecuted and punished for the same offense more than once. But if you read the second principle, departmental proceedings are independent of trial. The second principle is very, very important. A departmental proceeding is an independent thing. So the correct answer is Eric's termination will not amount to double jeopardy as departmental proceedings are independent of trial by judicial courts. Option C is the right answer. Option C is the right answer. Am I clear? Everyone? Okay. Departmental proceedings are independent of trial by judicial courts or tribunals. So his termination will not amount to double jeopardy. Departmental proceedings are independent. Very important. Question number 13. I am solving questions along with you. See. Agreement, the meaning of which is not certain or capable of being certain, are void. Argon bought a car from Bini for a certain price, coupled with a promise to give 10,000 more if the car proved lucky for him. If the car proved lucky for him. Now, this is little controversial. I will give you suppose I say, I want to sell my pen for 10,000. You say, okay, I will buy it for 10,000, provided if it is lucky for me. How can I ensure that this pen will be lucky for you or not lucky for you? Am I clear? Now, these kind of things, lucky, proved lucky for him, becomes uncertain. The agreement is void for uncertainty. The agreement is void for uncertainty. Very good, very good. आप लोग बहुत अच्छा कर रहे हो. Is that clear? So option D is the right answer. It is difficult to determine good, bad, or hard luck. You can't determine that. Okay. That is little uncertain. Okay. That becomes little uncertain. Am I clear, everyone? Okay. Let's move on. Question number 14. The three principles are given over here. Is that clear, everyone? Can you read the entire slide? The three principles. Mischief. What exactly is mischief? Right? Chalo. Let's read the question. Clark has a joint property with Bruce. So Bruce and Clark has a joint property in a horse. So Clark shoots the horse, intending thereby to cause wrongful loss to Bruce. Is it mischief? You are causing loss by, suppose I share an office with Mr. A, and to cause wrongful loss to A, I burn that office. I also am the 50% shareholder of that office. But I have done an act which is causing loss to someone. So Clark will be guilty of mischief as he intended to cause wrongful loss to Bruce. Am I clear? Is that clear? He had a joint property. He shoots that horse which belonged to both to cause wrongful loss to Bruce. Is that clear, everyone? Zoya, no. Mayank, yes. Okay. Read the solution, every one of you. Okay. It is categorically stated in the principle itself, the intention part. Okay. So it makes things very easy and very clear to each and every one of you that it amounts to mischief. I'm moving on to question number 15. Okay. Question number 15. If in the exercise of right to private defense against an assault which reasonably causes the apprehension of death, the defender has to be situated that he cannot effectually exercise the right without risk of harm to an innocent person. His right of private defense extends to the running of that risk. Now let's read the facts. John is attacked by a mob who attempts to murder him. He cannot effectually exercise his right of private defense without firing at the mob. He cannot fire without risk of harming younger children who is mingled with the mob. John, to save his life because people are trying to kill him, fired at the mob and one of the child dies as a result of that firing. Which of the statement is correct? Read it once again. Right of private defense. Okay? Yeah. Can he say that he is protected under the right of private defense? John is liable for murder. John is liable for culpable homicide. John is liable for death by negligence. John is not liable. Tell me the correct answer. The correct answer is option D. John is not liable because this is what we understand as private defense. This is what we categorically understand as private defense. Am I clear? Is that clear to each and every one of you? Every one of you. Okay. Question number 16. Read it. I'm not going to read this with you. During one such interval when he was not in his proper sense. During one such interval when he was not in his proper sense, he enters into an agreement. Is that clear, everyone? He entered into an agreement when he was not in his proper senses. And the law says that for an agreement to become a contract, when a party is entering into a contract, he should be in his senses. So the correct answer is that clear? He can't enforce. Is that clear? So guys, are you understanding these sessions? Because these sessions will be very, very important for you. Okay. We will come with top 50 questions on these topics. Okay. So this is just the first session. We will have a couple of more sessions like these in the coming days. Okay. Question number 17. So if you intend to take something dishonestly, a movable product out of the possession of the person without that person's consent, it is called theft. The consent mentioned above may be express or implied and may be given either by the person in possession or by any other person having that purpose authority, either express or implied. This is the facts. Archie, being on friendly terms with Augie, goes into Orgy's library in Orgy's absence and takes away a book without Orgy's express consent for the purpose merely of reading it and with the intention of returning it, assuming that Archie have Orgy's implied consent to use Orgy's book, decide, is it a case of theft? Tell me. Intention plays a very important and a crucial role in criminal law. If you are taking away something intentionally with the intention of returning it, so the correct answer is Archie has not committed the offense of theft as he had Orgy's implied consent. Am I clear, everyone? Is that clear? So the correct answer is he was in good friendly terms. He says, okay, if I have a friend of mine, I say that, okay, come over and you can use my library. And he comes over, he picks a book, goes home with the intention of returning it back. That won't amount to theft. That will not amount to theft. Okay. So how was it? Did you understand these 17 questions that I have discussed with you in the course of this session? And if you have, do subscribe and press the bell icon. Do follow us on our Instagram. Do like our Facebook page. Do join our Telegram channel. And definitely do not forget to download the BYJU'S Exam Prep app. With this, we come to the end of this session. Thank you very, very much. God bless you. Stay home, stay safe, stay healthy. Have a great year ahead. Wishing all of you and your family members, your relatives, everyone a very happy and a prosperous New Year 2023. Bye-bye. Take care. Stay safe.